Now, because of that, I think I've probably got the real privilege of introducing Helen to some of you, because if this was a group of family lawyers, you would all know Helen's work already, because to my mind, she is certainly one of, if not the most original, creative and interesting thinker in family law at the moment. And her work touches on a lot of the themes that were picked up in the discussion this morning. So if this were a family law audience, I wouldn't be introducing her, but given that it's not, I'm assuming that she will be new to some of you. So it's really a great privilege to be able to introduce her. Helen works at Birkbeck College, University of London. And she's going to talk for up to 45 minutes, which will then leave us a good half an hour for discussion and questions.
Thank you, Sally. That's very kind. Can you hear me at the back? You can. If you can't, just about. Okay, if you can't, let me know. We've just had a debate about sitting down or standing up, so I'll stand up if it becomes difficult. What I want to do in this paper is I want to trace a trajectory in the law from parents' rights to parental responsibility. That's the first thing I want to do. And then I want to move on and to look specifically at the reasons that the courts give for granting parental responsibility. And in that specific context, I want to argue that there's been a shift in the meaning of parental responsibility from parental responsibility as parental authority to parental responsibility as therapy. And I want to argue that that trend both illustrates and reflects what Frank Furedi, among other commentators, have called therapy culture. Okay, so to start by looking at tracing this trend from parents' rights to parental responsibility. There's no doubt, and it's not really contentious, that with the passing of the Children Act in 1989, parental responsibility ousted parental rights as the dominant legal conception of the parent-child relationship. But why was that? Why did parental responsibility replace parents' rights? Well, I think Martha Feynman, in her recent book, The Autonomy Myth, puts her finger on this when she says, obviously writing about the US, but she says, the charge levelled at parents' rights was that parents' rights treated children as though they were the property of their parents. That undoubtedly was the charge levelled in the UK. It was the charge levelled by the Law Commission, who many of you will know engineered, introduced and basically manoeuvred into the law the concept of parental responsibility. They said back in 1982, when they introduced the concept into legal discourse, they said the concept of parental rights, in the sense of conferring on a parent control over the person, education and conduct of his children throughout their minority, reflects an outdated view of family life, which has no part to play in a modern system of law. It was also a charge that was levelled by commentators at the time, contemporaneously with the passing of the Children Act. So Professor Michael Freeman, writing in 1991, the year that the Children Act was implemented, said, in one of my favourite quotes of all time, he said, "The shift from parental rights and duties, a property concept almost, to parental responsibility, with parents as trustees for their children, the beneficiaries, has to be welcomed. We clearly have to get away from the notion of children as consumer durables, completing a family after the CD player and video recorder." And it's also a charge that's levelled by commentators looking back at that shift from parents' rights to parental responsibility. So Jonathan Herring, writing in his latest edition of his family law textbook, says that the shift from parents' rights to parental responsibility demonstrates that, and I quote, "children are not possessions to be controlled by their parents. but instead children are persons to be cared for. So there's no doubt that that charge that parents' rights treat children as their parents' property does and did characterise the legal consensus. But even so, Martha Feynman is right, I think, when she says that the charge is an inflammatory characterisation that does more to obscure than to illuminate the issues. To go back to Jonathan Herring's characterisation of the shift, in living memory, the idea that children are their parents' possessions has never been legally endorsed, nor the idea that children are persons to be cared for ever been legally doubted. To go back to Professor Michael Freeman's description of the role that children play in the family, every time I hear that quotation, I can't help thinking of the old joke. If I can risk a joke here, and I do apologise to Sally, who's heard this joke from me before. But it always makes me think of that old joke. What's the difference between an elephant and a postbox? I don't know. What is the difference between an elephant and a postbox? Well, if you don't know, I won't ask you to post my letters. There is no confusing the way that children and CD players complete a family. There is no comparison between the way that children and DVD players add to a family. Indeed, parents commonly lament the failure of children to have an off switch, a volume control, or even a pause button. But more seriously, that charge that parents' rights treated children as their parents' property was wrong, because it was crystal clear that far from treating children as parents' property, the law treated parental rights as existing for the benefit of the child, not for the benefit of the parent. Now, that was entrenched in the law in the case of Gillick, which most people will remember was a House of Lords case in the mid-1980s that determined that older children had the power to consent to contraceptive advice and treatment without their parents' knowledge in certain circumstances. So that was entrenched in the law in that case. According to Lord Fraser, speaking in the House of Lords in Gillick, parental rights to control a child do not exist for the benefit of the parent. They exist for the benefit of the child, and they are justified only insofar as they enable the parent to perform his duties toward the child, hence the decision in Gillick. So that was made clear by the law, by the case of Gillick. But it wasn't in contention in Gillick. Both sides in the dispute agreed on that point. And Lord Scarman in particular, in Gillick, made clear that he was spelling out a long-standing legal principle which he traced right back to 1830. And the Law Commission agreed with this. They agreed that it was clear that parents' rights existed in the law for the benefit of the child, not for the parent. They said in 1985, to the extent that the law enables parents to decide how to bring up their children without interference, it does so to promote the welfare of the children. But even so, even though it was quite clear that that charge was wrong, that parents' rights didn't treat children as their parents' property, that was the reason. It was concerned to emphasise that parental powers were for the benefit of children, that provided both the initial and the main impetus for that shift from parents' rights to parental responsibility. And that's quite clear from the 1982 Law Commission report, which I'm not going to go through at this point, but the evidence, is really there in that report. Can you hear me at the back, or do you need me to stand up? You can hear. Okay, that's great. So we've got this switch in the law from parents' rights to parental responsibility taking place, culminating in 1989 in the passing of the Children Act. And as I say, it was wrongly based on this idea that parents' rights treated children as their parents' property. So the question then is, well, did that switch matter? Did it matter that the law shifted from talking about parents' rights to parental responsibility? And at first glance, and at first, I think the answer to that question was no, it didn't actually matter. Originally, that shift from parents' rights to parental responsibility was conceived of as, to quote Lord Mackay, speaking in 1989, largely a change in nomenclature. Similarly, the Law Commission, who introduced the change, promised, if you want to put it that way, in 1988, that this change would make little difference in substance. So, to put it in another way, originally, in 1989, parental responsibility had a lot of parents' rights left in it. And you can see that in the definition of parental responsibility in Section 3 of the Children Act 1989, which defines parental responsibility as all the rights, powers, duties, etc. that parents have over their children. So a number of commentators have made the point that that throws you straight back onto rights. So it was quite plausible in 1991 when John Ekeler described parental responsibility as synonymous with parental authority, embodying for him at that point ideas of freedom of parents from government. So what's the problem? Well, to turn back to Martha Feynman for one last time, she warns that the ideals embodied in the substitution of egalitarian concepts for parental rights, and I quote here, amorphously appealing on a rhetorical level, seem harmless enough as aspirations. The problems arise when they are implemented into laws that can be used at the relatively unfettered discretion of various state actors to undermine, even usurp, parental decision-making authority. In other words, parental responsibility is a much more slippery concept than parents' rights. It's much easier for parental responsibility to change its meaning than it would have been for parents' rights to change their meaning, although there was some of that as well, of course. So what I'm saying is that the switch from parents' rights to parental responsibility in the law set the stage. It enabled a switch in the meaning of parental responsibility, accompanied by a concurrent shift from the old, well-established idea that parental authority existed for the benefit of children to the new idea that parental authority was itself antithetical to children's welfare. I've previously looked at this shift in the meaning of parental responsibility from different angles. I've looked at it in relation to parental responsibility for children's crimes and misdemeanours, parenting orders and so on. And what I've argued in that context is that parental responsibility has changed its meaning to that of parental accountability. I've also looked at this in the context of the allocation of parental responsibility. And I've argued that in that context, parental responsibility has begun to mean nothing more than legitimation. What I want to do in the rest of this paper is I want to focus in on a particular aspect of the allocation of parental responsibility. As I said at the beginning, I want to look at the reasons that the courts give for granting, or obviously not granting, parental responsibility. And as I said at the beginning, I want to argue that in that context, parental responsibility now means therapy. Of course, the common thread in what I've argued in all of those, in all of that work, and it's a thread that does resonate with the previous session, is that in all of those contexts, parental responsibility no longer means parental authority. It means something different in different contexts, but the common thread is that that meaning has been lost. How am I doing for time?
You're 8 minutes off halfway.
Okay,
Still.
that's fine.
Before, later
So
time.
I've still got some time.
Yeah.
So I want to turn then to look at the reasons that the courts give for granting parental responsibility. Now, because we're not all lawyers in the room, in fact, as Sally said, we're in a small minority, I just need to say a couple of things about the law at this point for this all to make sense, I hope. All the cases that I'm looking at, all the cases about whether to grant parental responsibility or not, are all cases about unmarried fathers. They're all cases of unmarried fathers applying for parental responsibility. And that's because until very recently, unmarried fathers were the only group who were able to make that application in the law. As the lawyers will, of course, know, all mothers and married fathers have parental responsibility automatically, but unmarried fathers were and are able to apply for parental responsibility. Now, some people have seen, therefore you could see what I'm going to talk about now as being about unmarried fathers specifically. I don't see it that way. I see it as of more general application. Time will tell whether that's right. Another thing that I just want to flag up at this point, particularly for the vast majority who aren't lawyers, is that there's another concurrent trend that's taking place with parental responsibility. And that is that at the same time as what I'm going to look at, and it's very much related, parental responsibility is having less and less effect. Obviously, this is very closely related to what I'm talking about. You can do less and less with parental responsibility. And what the courts have been stressing increasingly is the symbolic importance of parental responsibility, the symbolic dimension. I'm not going to go into that trend in any detail at this point. That's something I've written about elsewhere. But I think it's something you need to be aware of to make sense, to put this all together. So what am I saying about the reasons that the courts give for granting parental responsibility? Well, essentially, in a sentence, I'm going to argue that there's been a shift from the courts granting parental responsibility on the basis of what the father can do with it to give the father decision-making power, away from that to giving the father parental responsibility because of how the parties feel about it. A shift away from decision-making power to the parties' feelings and emotions. How will this make them feel if it's granted? So I'm going to have a look at the earlier cases, which I'm arguing are about decision-making power, and then turn in slightly more detail to the later cases, which put emphasis on feelings and emotions instead. So in the leading case of Reece in 1991, one of the earlier cases, post-Children Act on parental responsibility, the question that faced the Court of Appeal here was what to do when parental responsibility, parental powers weren't enforceable. And the Court of Appeal were quite clear that just because all the powers couldn't be enforced, that wasn't a reason not to give parental responsibility. The thing that worried the Court of Appeal more in this case was that in this particular case, the trial judge had already decided that the children were going to be freed for adoption despite the father's opposition. So the problem for the Court of Appeal was, is there any point giving the father parental responsibility when it's going to be immediately taken away from him by the freeing order? You know, isn't that just a waste of everybody's time? But they did give him parental responsibility. But the reason that they did that was that they pointed to some very limited rights that he would still have even after the freeing order. So, for example, the father in that case still had the right to receive progress reports on his children. And even more importantly, he had the right to apply to revoke the freeing order in certain circumstances. Now, the point that I'm making about that case is that it was those residual rights that the Court of Appeal used as a reason for granting parental responsibility, nothing to do with how the father felt about having parental responsibility. Similarly, in a case the next year, a case called Reece in 1992. Again, this was about what do you do when parental powers aren't enforceable. And again, in this case, the powers weren't enforceable at the present point. And in this case, the reason that the court granted parental responsibility was that there was a possibility that the father would be able to exercise parental powers in the future. So the court said in this case that parental responsibility had real and tangible value as a status carrying with it rights in waiting. It was that potential value that formed the basis for granting parental responsibility, and again, nothing to do with feelings and emotions. And finally, the final example of an earlier case that I'm going to give is a case called Reece in 1994. And in that case, the court said that the father's reason for wanting parental responsibility, that he wanted the ability to have a say in his child's life, was a proper reason and an appropriate factor. The court said it was in the child's interests that the father should be given a proper part to play by being given a locus standi. So those are the earlier cases. Then we get to a case in 1995. Obviously, it's very dangerous to pinpoint one case, but I do want to suggest that this case, a Court of Appeal decision in 1995, represents a little bit of a turning point in the law and really does point the way for the cases that have come since. And it's no coincidence that this case also marked a significant rupture between parents' rights and parental responsibility. Up until Reece, the courts had mainly agreed with the Law Commission that, oh, well, it's just another way of saying the same thing. Brilliant, that's just where I should be. That it was just another way of saying the same thing. But in this case, the Court of Appeal said, no, that underestimates the fact that parental responsibility is a break with the past. It's a break with parents' rights. But I'm not going to talk about that more here, but I think that's no coincidence that this case also marks a significant rupture there. What I do want to talk about, though, in some detail, is that in this case, Lord Justice Ward in the Court of Appeal gave an entirely new reason for granting the father parental responsibility. And the joys of modern search tools like Lexis and so on enable me to say that with some confidence, at least in form and I think also in substance. This reason for granting parental responsibility had never been used before. And this was to give the father a stamp of approval. And I'm going to read a quotation from this case. It's a fairly long quotation, but I'm going to return to it a few times in what follows. So I do want to read this whole quotation. So what Lord Justice Ward says, this is his reason for granting the father parental responsibility in this case. He says, I have heard up and down the land psychiatrists tell me how important it is that children grow up with good self-esteem and how much they need to have a favourable positive image of the absent parent. It seems to me important, therefore, wherever possible, to ensure that the law confers upon a committed father that stamp of approval, lest the child grow up with some belief that he is in some way disqualified from fulfilling his role, and that the reason for the disqualification is something inherent, which will be inherited by the child, making her struggle to find her own identity all the more fraught. Now, what I want to argue in the final part of the paper is that this case and the cases that follow it illustrate and reflect some themes in what Frank Furedi has described as therapy culture. Now, I just want to sort of issue a quick disclaimer here. I'm not trying to provide a summary of therapy culture. Obviously, Frank Furedi would have been much better placed to do that. And I'm not trying to do a sort of thumbnail sketch. It's not possible to listen to what I'm going to say and then say, well, that's the main, those are the main threads of therapy culture. What I'm trying to do here is to plunder therapy culture to draw some links with the case law on parental responsibility. So it's not at all a kind of, I can't think of the word, comprehensive account of therapy culture. And the other thing I just want to make clear is that I'm drawing on a few different sources here when I talk about therapy culture. Frank Furedi, James Nolan, Christopher Lash, Nicholas Rose, just to mention a few. And of course I do appreciate that there are enormous differences in their descriptions and accounts of therapy culture, not least whether they think it's a good thing or a bad thing. They don't all agree on that. So I just want to admit that in some of what I'll be saying, I am glossing over those differences and talking about therapy culture as something perhaps more cohesive in those different authors' work than it actually is. So I want to now look at some of these themes, though, in therapy culture and to draw some links between those themes and the case law. So perhaps the obvious starting point in understanding what Furedi and others are talking about when they talk about therapy culture is an emphasis on emotions, an emotivist ethic. James Nolan puts it this way, that in modern society, emotions are central to our personhood. Frank Furedi puts it perhaps even stronger when he says that a turn towards emotionalism represents one of the most significant developments in contemporary Western culture. And very closely related, that emotivist ethic implies that vulnerability, as opposed to strength, characterises our psyche. And I think you can very clearly see that theme in the passage in Reece. The child's struggle to find her own identity is made all the more fraught by a lack of parental responsibility. Similarly, perhaps even stronger, in another case in 1995, a case called Reece. This was a case where the child had found out that the person who he thought was his father was actually not his father. And Lord Justice Ward in that case granted the man parental responsibility. And the reason for doing so in that case was that here I'm quoting Lord Justice Ward, the benefits of parental responsibility should be impressed upon the boy to give him the confidence that he has not suffered some life-shattering blow to his self-esteem. Now that last quotation introduces the next theme in therapy culture that I want to flag up, and that is the emphasis on self-esteem, which is stressed particularly by Frank Furedi in therapy culture. It's obviously evident in that last quotation. It's also stressed in that case that I started with of Reece, the importance of the child growing up with good self-esteem. Moving on, the emphasis on vulnerability in therapy culture. Frank Furedi suggests in his book, leads an ever-widening range of human experiences to be regarded as traumatising. A greater number of things that happen to us are regarded as causing us harm. And again, you can see that very clearly in the quotations that I've already mentioned. The fraught struggle for identity, the life-shattering blow. And that's very closely related to another theme that we talked about a lot in this morning's session, and that is the idea of emotional determinism, that what happens to us as a child determines our adults' lives. The way that Furedi puts it at its most strongest is that adults are simply living out a script that's been created by their childhood. And that seems really to come out in the case of Reece. We're told that it's important that the father has parental responsibility, lest the child grow up with some belief that the defect that stops the father having parental responsibility is something inherent which he might inherit. As if, there could be some gene for not having a parental responsibility order. Just to stand back from the cases for a few minutes, it really does come to something. It is a mark of how far culture has become therapeutised, when having a father without a parental responsibility order is classed as a traumatising experience that determines a child's future life chances. I don't like to get personal in my papers, but I do have to say at this point that that fate of having a father without a parental responsibility order is a fate suffered by one, but not the other, of my own children. And remember, bear in mind, that this order, the parental responsibility order, that will cause this child to suffer this life-shattering blow to their self-esteem, is a legal order with no tangible effect on the child. We're not talking about a contact order here, where, yes, obviously, of course, if you can't see a parent, whom you care about, that is obviously a distressing experience, and a legal order might well be needed to sort that out in some circumstances. We're talking here about a parental responsibility order which doesn't change the child's life at all in any material way, and yet the absence of it is traumatising. And it's also really worth noting that in all of the cases I've mentioned so far, there was absolutely no evidence given in any of those cases that the child would be traumatised by the lack of a parental responsibility order. Unless, of course, you count Lord Justice Ward going up and down the land listening to psychiatrists. Now, at this juncture, the therapeutic reasoning focuses on the child's needs. But then there are two other themes in therapy culture that I want to suggest explain why there's a shift in the cases to a focus on the adult's feelings and emotions and needs. The first of those two themes is one that, again, we talked about this morning a lot. And that is that blurry line between adults and children. We talked about whether that was about childhood being extended or being contracted, but certainly I think there was a general understanding that the line between what an adult is and what a child is has been blurred. And in therapy culture, Frank Furedi ties that in with an emphasis on vulnerability generally, so that adults are seen as childlike in the sense that they are also vulnerable, victim-like, and need to be protected. And I think in this particular context, where, as I said, I explained a little while ago, we're talking entirely about cases about unmarried fathers, I think this point is also supported by Sally's observation in her recent book, Fragmenting Fatherhood, that there is an emergent and increasingly dominant sense of unmarried fathers as a particularly vulnerable group. So that's one thing, this blurring of the line between adults and children, and particularly unmarried fathers being seen as, a group at risk. The second theme, which leads to a focus on the adult's feelings rather than, or in addition to, the child's, is the self-referential character of therapy culture. To break that down a little bit, James Nolan argues in his book The Therapeutic State that in therapy culture, the self becomes the ultimate object of allegiance. The relationship that counts is the relationship with the self, and the responsibility that counts is the responsibility to the self. Frank Furedi makes a similar point in a slightly different way when he says that in therapy culture, feeling good about yourself becomes the ultimate goal. Now, if that's right, that makes the traditional basis for granting parental responsibility problematic. Traditionally, a parental responsibility order might have been granted because it was best for the child, or because it was a way of the father showing his commitment to the child for somebody else. I don't want this parental responsibility, but I think I need it to help the child. Now, if the self becomes the object of allegiance, if what counts is feeling good, what counts is having responsibility to yourself, then it would make sense that the emphasis would shift onto how the father, the applicant, feels about having parental responsibility. And that is actually what we see in the most recent cases. And the lovely example of this is a case called Re D in 2006. Now, in this case, a lesbian couple wanted to have a child. So they advertised for a man to father the child. And Mr. B came forward and he did father the child. But then when the child was born, it soon became apparent that the adults in that case had different understandings of the role that Mr. B would play in the child's life. And so as a result of that, Mr. B applied for parental responsibility over the child. And he was granted parental responsibility. But he was granted a very, well, I've called it degraded form of parental responsibility, because the judge also told him that he couldn't do anything at all with his parental responsibility, to the extent that he actually wasn't allowed, by legal order, to contact the child's school or the child's, health advisors. He was ordered to keep away. So he was granted parental responsibility, but he couldn't do anything with it. So then the question becomes, why on earth would he be granted this legal order if he was also told that he could do absolutely nothing with it? And this is the reason, what I'm going to say now is the reason that the judge gave for granting Mr. B parental responsibility. He said, the judge said, for Mr. B, to be D's father is simply not enough. He wishes to be recognised as a father and a parent, and he perceives that a parental responsibility order would bring this recognition. The judge said, Mr. B's motives have at their root his wish to be recognised as belonging to the child. And I will say for the lawyers present that I have cut that second quotation. So it perhaps, is more complex in the original, but that is the quotation. I would also, just on this point, I would say quite tentatively that perhaps, looking at that quotation in this case, perhaps it also illustrates another aspect of the self-referential nature of therapy culture. And that is that the self in therapy culture is defined by how it feels, not what it does. The way that Freire puts it is that approval becomes an act of affirming the self, not evaluating somebody's achievements. Because, if you follow that through, that the self is evaluated by how they feel, not what they do, then awarding parental responsibility for what the father might do with it becomes problematic, and awarding parental responsibility because of how the father feels about having it becomes more a sensible way, a sensible route. I make that point quite tentatively because I do recognise that making a decision about what school your child is going to go to or something like that is not really the pinnacle of human achievement. We're not really talking about a great achievement in that. But even so, it seems that there is a downgrading of what you might do with parental responsibility and an upgrading of how you feel about it. Oh no. But I am on the final theme now, so that's good. And the final theme that I want to look at in therapy culture leads us back into the heart of the law. The final theme in therapy culture, to quote Freire for the last time, he says that in therapy culture, the self is not so much affirmed or realised through the activities and relationships of the individual, but through the legal form. We seek acknowledgement through law rather than through our relationships with each other. And I think you can see this very clearly in the case law on parental responsibility in relation to both the adult and the child. So looking first at the child, later on in the case of Reece, the case that I started this with, the 1995 case, which I argue sort of sets this trend in motion, Lord Justice Ward refers to the importance of children growing up in the knowledge that their father is committed enough to wish to have parental responsibility conferred upon him. And similarly, 2 years later, in the case called Riem, Lord Justice Ward says, "It is essential for the well-being of the children to begin to know that their father was concerned enough to make an application to be recognised as their father, and that his status as their father has the stamp of the court's approval." So it's important for the child to know that their father was concerned enough to apply to the court for a legal order with no effect. Not important for them to know, rather than important for them to know that he was concerned or committed enough to spend time with them, or even to, buy them an ice cream or something like that. It's important for children to know that the father's status has the stamp of the court's approval, not that all their school friends know that he's their dad. This point is taken even further in a case in 2002 called Re-H, where Lord Justice Thorpe says that a parental responsibility order would benefit the child in years to come so that she knows that she has two parents. So here, the very act of knowing that you have two parents depends on the court's official stamp. That's from the point of view of the child. From the point of view of the father, to return to the case of Re D in 2006 that I mentioned a few minutes ago. Again, I've used this quotation before just to remind you. The court said, for Mr. B to be D's father is simply not enough. He wishes to be recognised as a father and a parent, and he perceives that a parental responsibility order would bring this recognition. So just a few points here. As for the child, remember that this is a legal order with no effect on the father's life. So it's not the effect of the order that will make the father feel better, but the order itself. Of course, at times, we will all need the effects of legal orders. So, if somebody owes you money and they won't pay it to you, of course you need to go to court, ask the court to enforce, to order them to give you the money, and you enjoy the effect of the order, which is the money. Similarly, in family law, you might need the effect of a contact order to enable you to see your child or to see a child. But here, we're not talking about the father feeling good because of the effect of the order, but because of the order itself. And I think here, Jonathan Herring is absolutely right to describe parental responsibility in this context as a pat on the back, official confirmation. But remember as well that this is still an order for a status. It is still an order with some powers attached to it and flowing from it, and yet it's being granted to make an adult feel good. And this seems to me quite a remarkable legal development. I'm struggling to think of any other status in the law that is granted to make people feel good. I mean, if you, for example, want to know whether legally you're somebody's wife or somebody's mother, the court, as yet, doesn't say, well, how do you feel about it? Would you like to be considered to be their mother or their wife? They look at the conditions and whether they are met and whether you are entitled to that status. So here we have, I think, an interesting new development. I'd be interested if there are any other examples of this, where a status is being granted to make an adult feel good. In a different context, I think Andrew Bainham is right to describe this need to be recognised as status anxiety, a term that he attributes to de Botton. So just to conclude, I'm sure to Sally's relief, what I'm arguing is that parental responsibility currently is, but should not be, awarded to prevent adults feeling that otherwise the law has emotionally neglected them. Parental responsibility should be, but is not currently. It should be granted to adults if and only if they deserve parental responsibility. But I do recognise in saying that I am falling into a catch-22, because that would involve parental responsibility actually meaning something. That's it.